The meeting is now called to order. Good afternoon. Whether you're joining us in person or via live stream on this website, I welcome you all to this public meeting of the United States Sentencing Commission, the first meeting of 2023. Now I have the pleasure of introducing my colleagues. First, I'd like to introduce the Commission's Vice Chairs. Claire Murray here to my right, who most recently served as Principal Deputy Associate Attorney General, and Laura Mate, who served as the Sentencing Resource Counsel to the Federal Public and Community Defenders for many years. Also with us today, District Judge Claria Horn-Boone, who serves in both the Eastern and Western Districts of Kentucky. Candace Wong, who is an Assistant United States Attorney and the Chief of the Violence Reduction and Trafficking Offenses Section in the United States Attorney's Office in Washington, D.C., and the Commission's ex officio member representing the Attorney General, Jonathan Robluski. Joining us by phone today is Judge Louis Felipe Restrepo, who serves on the United States Court of Appeals for the Third Circuit, and Commissioner John Gleason, who previously served in the Eastern District of New York. Patricia Kushwa, the ex officio member representing the United States Parole Commission, was unable to join us today. The first order of business is to vote to adopt the October 28th, 22 public meeting minutes. Is there a motion to do so?
So moved.
Is there a second?
Second.
I got a timid group with me today. Is there any discussion on this motion? There is no discussion. Please vote on the motion by saying aye, and if you don't agree with the motion, you can say nay.
Aye.
All right. Thank you. The motion is adopted by voice vote. The next item of business is the report of the chair. This is my opportunity to talk to you all. Happy New Year again. There are no shortage of practices and traditions throughout the world that are believed to bring success and good things in the new year. Some, like myself, from the South, we eat black-eyed peas. But if you're from Mississippi, you eat black-eyed peas, you got to have the cabbage greens, and you also have to have cornbread. And note I said cabbage greens and not simply just cabbages. That's my Yazoo City tradition. I've learned, though, that others eat fish for luck and prosperity, while some smash dishes. And there are those, I've learned, who jump 7 times in ocean waves. I even heard of others eating 12 grapes at the stroke of midnight on January the 1st, each grape representing a month of the year. Regardless of how we all brought in the new year and the traditions we practice, I have no doubt that 2023 will be a very busy but good and successful year for this commission. We've worked hard, and we will continue to do so. When my esteemed colleagues and I were confirmed by the Senate back on August 4th, not even 6 months ago, we knew we had a lot of hard work ahead. After 4 years without a voting quorum, the commission was faced with quite a backlog of policy work. By statute, we must submit our amendments to Congress for review no later than May 1st, 2023. That's less than 4 months away. We know that we're working under an abbreviated amendment cycle, but we are committed to meeting our deadlines with the focus on this initial amendment cycle on the most urgent policy concerns. The commission and its staff. We've worked. As the saying goes, we've worked full steam ahead. Quite frankly, I'm constantly amazed with the amount of work and with the efficiency that the staff works. We, the commission and the staff, have worked hard. We've worked thoroughly, and we've worked diligently and thoughtfully. This work has led us to today's deliberations on our proposed guideline amendments. Before I turn to those amendments, however, I would like to provide an update on the additional work the Commission has been doing over the past few weeks, as well as a look ahead. Last month, the Commission released an updated compassionate release data report, examining motions filed with the courts during fiscal years 2020, 2021, and 2022. This report follows the significant work the Commission has done over the past few years. Consistent with previous reports on compassionate release, the Commission found that the likelihood of compassionate release motions succeeding varied significantly depending on the circuit or district in which they were filed. The First Step Act amended Title 18 United States Code, Section 3582, to allow defendants for the first time to move for compassionate release on their own without having the director of the Bureau of Prisons to make a motion. In the absence of a Commission policy statement recognizing this avenue, courts of appeals generally have held the Commission's policy statement governing compassionate release does not apply to motions filed by defendants. Without guidance from the Commission during the COVID-19 pandemic, the debate about what constitutes extraordinary and compelling reasons for compassionate release motions became a debate within the federal courts throughout the nation and with differing results. It is the Commission's obligations to provide clearer guidance to the courts. We will do so. In fact, implementation of the First Step Act is among our top priorities and one that we will discuss today. In light of the patchwork of state laws regarding simple possession of marijuana, as well as recent administration policy developments on the federal level, this week the Commission released a report titled, Weighing the Impact of Simple Possession of Marijuana, Trends in Sentencing in the Federal System. The report looks at the number of offenders sentenced for federal offense of simple possession in the last 5 fiscal years, as well as the demographics and sentence lengths of these offenders. The Commission stakeholders asked, and again, we listened. I'm pleased to announce that the Commission will soon launch yet another valuable online resource. In the next day or so, the Commission will add an interactive data tool to the website that provides information on programs that offer alternatives to incarceration throughout the nation. Speaking of the website, please remember, there is so much information just at your fingertips, just fingertips away at www.ussc.gov. I implore you to visit and spend time at our website, at our site. It is easy to navigate and is packed with information for everyone: judges, law clerks, practitioners, stakeholders, the general public, and those who are simply curious about our federal criminal justice system. During the recent proposed amendment comment period, we received many requests for this information, and I have no doubt this new tool will add to the wealth of resources already offered by the Commission. This, of course, follows last year's launch of the Judiciary Sentencing Information Tool, a tool that we call JASON. As of late of 2022, JSON, which provides its users with comparative sentencing data, was accessed more than 1,300 times each month, and its data was cited in more than 1,700 pre-sentence reports. In addition, I'm happy to announce a new public comment portal on our website that will go live after this week's commission's meeting has concluded. By providing access to the list of proposed amendments and allowing letters and comments to be submitted through a fillable online form, this portal will make it even easier for those who want to offer comment on the Commission's proposed amendments. Of course, the Interactive Data Analyzer continues to be a regular resource for the federal sentencing community. Now, turning to an overview of today's agenda. It's a busy one. Today we will discuss the Commission's proposed guideline amendments and issues for comment. In addition to implementation of the First Step Act that I discussed earlier, we will discuss the safety valve, for which eligibility was expanded in the 2018 law. The Commission needs to amend Section 5C1.2 to recognize this change. But we also need to consider changes to the two-level reduction in the drug trafficking guideline for meeting the safety valve criteria. The Commission also intends to implement the bipartisan Safer Communities Act, firearms legislation that was passed after the Uvalde shootings and signed into law in July. The act directs the Commission to increase penalties for certain firearm offenders, particularly straw purchasers. I've heard consistently from judges throughout the nation that the categorical approach should be reconsidered. Judges are far too often flummoxed by how to apply the categorical approach. This is certainly a matter that the Commission will continue to discuss and one that may warrant a public hearing. In addition, we will examine status points and the treatment of offenders with zero criminal history points. Many judges and stakeholders have also told me that acquitted conduct is important to them. The Commission may consider possible amendments to limit the use of acquitted conduct in sentencing. The Commission's possible guideline amendments also include examining and resolving the most critical circuit conflicts regarding guideline interpretations as suggested in some denials of writs of certiorari. Yes, we have been busy, and I've outlined only a few of our priorities, but I know I join my colleagues in continuing to be grateful for this opportunity to serve our nation, this great nation, in this important capacity. I appreciate the feedback and the public comment we've received thus far, and I look forward to comments on the Commission's proposed guideline amendments. I now turn to Ken Coy, the Commissioner's Staff Director, as we move forward with today's agenda for the Staff Director's report.
Thank you, Judge. I just have one announcement. Raquel Wilson could not be with us today, but Raquel is retiring at the end of January. For bluer pastures, she's going to become a law professor at the University of Kentucky Law School teaching criminal law and criminal procedure, not far from Judge Boom, so you all will be neighbors. Raquel has had a long and incredibly successful and productive federal career. She clerked for Judge Robert Hinkle in the Northern District of Florida. She served as an assistant federal public defender in Asheville, North Carolina, and Houston, and as an assistant public defender in Tallahassee, Florida. She joined the commission in 2015 as my deputy general counsel when I was general counsel, and she has served as the director of our training unit, ESP, since 2009. Raquel has been just a remarkable contributor to the commission and to our training mission. She has trained thousands of judges, probation officers, lawyers, and the collective we are going to miss her, and I'm going to miss her deeply. In her stead, Alan Dorhofer will be acting director of training February 1st, and I am sure Alan, who's sitting to my left, will do an excellent job in Raquel's stead. That's all I have.
Thank you, Mr. Coy. I'd like to echo your sentiments. I was one of the ones that Raquel had a tough time training, I'm sure. I was one of the ones at Baby Judges School and the National Conference and all that. So we do appreciate all the work that she and her group of trainers did then and continually do for our judiciary. The next item of business is a possible vote to publish in the Federal Register proposed guideline amendments and issues for comment. The General Counsel, Kathleen Grilly, will advise the Commission on the first possible vote concerning a proposed amendment on the Commission's compassionate release policy statement. General Counsel.
Thank you, Judge Reeves. You have before you a proposed amendment responding to the First Step Act of 2018, specifically which, among other things, amended the sentencing modification procedure set forth in 18 U.S.C. 3582C1A. Your proposed amendment would implement the First Step Act's relevant provisions by amending what is colloquially referred to as a compassionate release policy statement found in 1B113 of the Guideline Manual and its accompanying commentary, to authorize a defendant to acknowledge that a defendant is also authorized to file a motion seeking a sentence reduction. The proposed amendment would also revise the list of extraordinary and compelling reasons in 1B113 in several ways, including revising the provision currently found in Application Note 1D of 1B113, also referred to sometimes as the catch-all. 3 options for that revision are provided. All 3 options would redesignate this category as other circumstances and would expand it to motions filed by either the Director of Bureau of Prisons or the defendant. Issues for comment are also included with this proposed amendment. A motion to publish the proposed amendment, as I've just described it, with a public comment period closing on March 14th, 2023, and technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Is there a motion to publish the proposed amendment as suggested by the General Counsel?
So moved.
Is there a second?
So moved.
Is there any discussion on the motion? No discussion? Well, why not? Let's vote. Oh, wait. Did I hear any comment from my colleagues on the phone? Okay, all right. Now we're ready for a vote on the motion. Please vote on that motion by saying aye.
Aye.
Any nays?
Aye.
Thank you. The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The General Counsel will now advise the Commission on a possible vote concerning a proposed safety valve amendment.
The proposed amendment before you also responds to the First Step Act of 2018, which, among other things, changed the eligibility criteria of the safety valve provision in 18 U.S.C. 3553F and the recidivist penalties for drug offenders at 21 U.S.C. sections 841B and 960B. The proposed amendment contains 2 parts, A and B, which are not mutually exclusive. Part A of the proposed amendment would implement the provisions of the First Step Act, expanding the applicability of the safety valve provision by amending 5C1.2 and its accompanying court commentary to reflect the broader class of defendants that are eligible for safety valve relief under the Act. Part A would also make conforming changes to 4A1.3 and changes to 2D11 and 2D111, as the 2-level reductions in both guidelines are tethered to the eligibility criteria of paragraphs 1 through 5 of 5C1.2A. It provides two options for amending 2D11 and 2D111. Part A also includes issues for comment. Part B of the proposed amendment would revise subsection A of 2D11 to make the guideline-based offense levels consistent with the First Step Act changes to the types of prior offenses that trigger enhanced mandatory minimum penalties. A motion to publish the proposed amendment with a public comment period closing on March 14th, 2023, and technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Is there a motion to publish the proposed amendment as suggested by the General Counsel?
So moved.
So moved.
Is there a second? Is there any discussion on the motion? I hear no discussion. Let's vote on this motion by saying aye. Let me hear any ayes.
Aye. Aye.
Any nays? No nays. Good. The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The General Counsel now will advise the Commission on a possible vote concerning a proposed firearm amendment.
Before you have a proposed firearm offense amendment, which is a result of your consideration of possible amendments to 2K 2.1. It's a 3-part amendment. Each of the parts are not mutually exclusive. Part A of the proposed amendment would amend 2K 2.1 to respond to the Bipartisan Safer Communities Act. 2 options are presented, as well as issues for comment. Part B of the proposed amendment addresses concerns expressed by some commenters about firearms that are not marked by a serial number, also referred to as ghost guns. An issue for comment is provided in that part as well. And Part C provides issues for comment on possible further revisions to 2K 2.1. A motion to publish the proposed amendment as I've just described it, with a public comment period closing on March 14th, 2023, and technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Is there a motion to publish the proposed amendment as suggested by the General Counsel?
So moved.
Is there a second?
Second.
Is there any discussion now on this motion? Well, let's vote on the motion. For those in favor of this motion, please vote in the affirmative by saying aye.
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 All right. Are there any nays? No nays. All right. The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The General Counsel will now advise the Commission on a possible vote concerning a proposed circuit conflict amendment.
Before you, you have the circuit conflict amendment. This proposed amendment contains 2 parts, A and B, again, that are not mutually exclusive. Part A of the proposed amendment would amend 3E 1.1 and its accompanying commentary to address circuit conflicts regarding the permissible bases for withholding a reduction under 3E 1.1b. Part B of the proposed amendment would amend 4B 1.2 by adding a definition of the term controlled substance to address a circuit conflict concerning whether the definition of controlled substance in 4B 1.2b covers only offenses involving substances controlled by federal law. An issue for comment is also included in each part. The motion to publish the proposed amendment as I've just described it, with a public comment period closing on March 14th, 2023, and technical and conforming amendment authority to staff would be appropriate at this time.
Is there a motion to publish the proposed amendment as suggested by our General Counsel?
So moved.
Is there a second?
Second.
Is there any discussion? No discussion, so let us vote. For those who vote in favor of this, vote by saying aye.
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 All right.
Aye.
All right. The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The General Counsel will now advise the Commission on a possible vote concerning a proposed crime legislation amendment.
The proposed amendment on crime legislation responds to recently enacted legislation. There are 11 parts, each of which are not mutually exclusive. Part A responds to the FDA Reauthorization Act of 2017 by amending Appendix A and the commentary to 2N 2.1. Part B responds to the Allow States and Victims to Fight Online Sex Trafficking Act of 2017 by amending Appendix A to G1.1. Part C responds to the FAA Reauthorization Act of 2018 by amending Appendix A and 2A 5.2, 2A 2.4, and 2X 5.2. Part D responds to the Support for Patients and Community Act by amending Appendix A and the commentary to 2B11 and 2B14. Part E responds to the Amy, Vicky, Andy Child Pornography Victim Assistance Act by amending Appendix A and the commentary to 2X 5.2. Part F responds to the Foundations for Evidence-Based Policymaking Act by amending Appendix A and the commentary to 2H 3.1. Part G responds to the National Defense Authorization Act for fiscal year 2020 by amending Appendix A and the commentary to 2X 5.2. Part H responds to the Representative Payee Fraud Prevention Act of 2019 by amending Appendix A and the commentary to 2B11. Part I responds to the Stop Student Debt Release Scam Act of 2019 by amending Appendix A and the commentary to 2B11. Part J responds to the Protecting Lawful Streaming Act of 2020 by amending Appendix A. Part K responds to the William M. Thornberry National Defense Authorization Act for fiscal year 2021 by amending Appendix A and the commentary to 2S 1.3. Each of the parts also include issues for comment. The motion to publish the proposed crime legislation amendment currently before you, with a public comment period closing on March 14th, 2023, and technical and conforming amendment authority to staff, is appropriate at this time.
Is there a motion to publish the proposed amendment as suggested by our general counsel?
So moved.
She said a lot of words, so it took us a while to digest. It has been moved, and I think I did hear a second.
We'll call it
Yes.
a second.
Okay. Is there any discussion on this motion? Now let's have a vote then. All in favor say aye.
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 Any nays?
Aye.
All right, thank you. The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The general counsel will now advise the commission on a possible vote concerning a proposed amendment addressing the categorical approach and other career offender issues.
You have before you a 4-part proposed amendment titled Career Offender, in which you're considering whether to promulgate any or all of these parts that are not mutually exclusive. Part A would amend 4B1.2 to address recurrent criticism of the categorical approach. It eliminates the categorical approach from the guidelines by defining crime of violence and controlled substance offense based upon a list of guidelines rather than offenses or elements of an offense. It would also make conforming changes to other guidelines that use those terms. Part B of the proposed amendment would address the concern that certain robbery offenses, such as Hobbs Act robbery, no longer constitute a crime of violence under 4B1.2 as amended in 2016. Part C of the proposed amendment would amend 4B1.2 to address 2 circuit conflicts regarding the commentary provision stating that the terms crimes of violence and controlled substance offense include the offenses of aiding and abetting, conspiring to commit, and attempting to commit crimes of violence or a controlled substance offense. 2 options are provided. And Part D of the proposed amendment would amend the definition of controlled substance in 4B1.2b to include offenses involving an offer to sell a controlled substance and offenses described in 46 USC Section 70503A and 70506B. Issues for comment are included with each of the 4 parts. A motion to publish the proposed career offender amendment with a public comment period closing on March 14th, 2023, and technical and conforming amendment authority to staff would be in order.
Is there a motion to publish this proposed amendment as suggested by our general counsel?
So moved.
Is there a second? Jump right in.
Second.
All right. Is there any discussion on this motion? Well, let's take a vote then. All in favor of following the advice of our general counsel and this motion, actually, say so by voting aye.
Aye.
Are there any
Aye.
nays? Thank you. The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The General Counsel will now advise the Commission on a possible vote concerning a proposed criminal history amendment.
The proposed amendment before you contains 3 parts, parts A through C. As with your other amendments, the parts are not mutually exclusive. Part A relates to status points under 4A1.1D, which adds 2 criminal history points if the defendant committed the instant offense while under any criminal justice system. Recent Commission research, recidivism research, and publications found that status points add little to the overall predictive value associated with the Commission's criminal history score. The proposed amendment addresses the impact of status points under the guidelines. 3 options are provided. Part B relates to 0-point offenders. Sentencing table in Chapter 5 is divided into 6 criminal history categories. Category 1 includes offenders with 0 criminal history points and those with 1 criminal history point. Recidivism data analyzed by the Commission suggests that offenders with 0 criminal history points have considerably lower recidivism rates than other offenders. Part B of the proposed amendment sets forth a new Chapter 4 guideline at 4C1.1 that addresses 0-point offenders. It would provide a decrease of 1 or 2 levels from the offense levels determined under Chapters 2 for offenders who meet certain criteria, and provides 2 options for establishing the criteria. Part B would also amend the commentary to 5C1.1 as part of the Commission's implementation of 28 USC Section 994J. It would address the alternatives to incarceration available to 0-point offenders by revising the application note in 5C1.1, and would make corresponding changes to subsection B2A of 4A1.3, and would amend Chapter 1, Part A, Subpart 1. Part C of the proposed amendment would amend the commentary to 4A1.3 to include sentences resulting from possession of marijuana offenses and as an example of when a downward departure from the defendant's criminal history may be warranted. Issues for comment are provided with each part. A motion to publish the criminal history amendment with a public comment period closing on March 14, 2023, and technical and conforming amendment authority to staff is appropriate at this time.
Is there a motion to publish the proposed amendment as suggested by our General Counsel?
So moved.
Is there a
So
second?
moved.
Is there any discussion on this motion? Let's vote on the motion by saying aye. All in favor of this motion, please say aye.
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 All right. Any nays?
Aye.
Thank you. The motion is adopted, and please let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The General Counsel will now advise the Commission on a possible vote concerning a proposed acquitted conduct amendment.
This proposed amendment is a result of the Commission's consideration of possible amendments to the guideline manual to prohibit the use of acquitted conduct in applying the guidelines. Currently, consideration of acquitted conduct is permitted under 1B1.3, 1B1 in conjunction with 1B1.4 and 6A1.3. The proposed amendment would amend 1B1.3, the relevant conduct guideline, to add a new subsection C that provides that acquitted conduct shall not be considered relevant conduct for purposes of determining the guideline range unless the conduct was admitted by the defendant during a guilty plea colloquy or was found by the trier of fact beyond a reasonable doubt to establish part of the instant offense of conviction. The guideline would also include a definition of acquitted conduct and make corresponding changes to the commentary at 6A1.3. 2 issues for comment are also included. A motion to publish the acquitted conduct amendment with a public comment period closing on March 14, 2023, and technical and conforming amendment authority to staff is appropriate.
Is there a motion to publish the proposed amendment as suggested by the General Counsel?
So moved.
Is there a second?
Second.
Second.
Is there any discussion on the motion? Hearing no request for discussion, all in favor say aye.
Aye.
Aye. Aye.
All right, thank you. The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The General Counsel will now advise the Commission on a possible vote concerning a proposed sexual abuse offenses amendment.
The Sexual Abuse Offenses Amendment contains two parts that are not mutually exclusive. Part A responds to recently enacted legislation, specifically the Violence Against Women Act Reauthorization Act of 2022, which created two new offenses, one at 18 U.S.C. 250, titled Penalties for Civil Rights Offenses Involving Sexual Misconduct, and the other at 18 U.S.C. 2243C. The proposed amendment would amend Appendix A, the statutory index, to reference the new offenses under 18 U.S.C. 250 to 2H1.1, the Civil Rights Guideline, and offenses under 18 U.S.C. 2243C to 2A3.3, Criminal Sexual Abuse of a Ward. Issues for comment are provided. Part B responds to concerns regarding the increasing number of cases involving sexual abuse committed by law enforcement or correctional personnel against victims in their custody, care, or supervision. Part B of the proposed amendment would amend 2A3.3 in several ways to address these concerns. First, it would increase the base offense level of 14 to a bracketed 22. Second, it would address the presence of aggravating factors in sexual abuse offenses in the same way that 2A3.2 does by providing a cross-reference to 2A3.1. Issues for comment are also provided. A motion to publish the Sexual Abuse Offenses Amendment with the public comment period closing on March 14th, 2023, and technical and conforming amendment authority to staff is appropriate at this time.
Is there a motion to publish the proposed amendment as suggested by the General Counsel?
So moved.
So moved.
Is there a second?
Second.
Is there any discussion on this motion? Well, let's then vote. All in favor of this motion, please say aye.
Aye.
Any,
Aye. Aye.
any nays? All right. The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The General Counsel will now advise the Commission on a possible vote concerning a proposed issue for comment addressing alternative to incarceration programs.
The Commission identified as one of its policy priorities for the current amendment cycle a multi-year study of court-sponsored diversion and alternative to incarceration programs. As part of its work on this priority, the Commission has drafted issues for comment on alternative to incarceration programs to inform the Commission's consideration of this priority. There are 2 issues for comment provided. A motion to publish the issue for comment on alternative to incarceration programs with a public comment period closing on March 14th, 2023, and technical and conforming amendment authority to staff would be in order at this time.
Is there a motion to publish the proposed issue for comment as suggested by our General Counsel?
So moved.
Is there a second?
Second.
Second.
I'll receive Commissioner Wong's second to your motion to Judge Restrepo. I don't think they want us, I don't think anybody wants you seconding your own motion. But that's great. We're saying, oh, that was John. I'm sorry. I don't see you. I'm sorry. That's good. Okay. I'm sorry.
Helpful to know for record purposes anyway.
Thank you all. We just trying to liven it up. Since we've had the vote and the ayes, all ayes, let me hear that again. Did I hear everybody say aye?
Aye.
Aye.
Thank you. The motion is adopted. The motion is adopted. And let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The General Counsel will now advise the Commission on a possible vote concerning a proposed amendment addressing fake pills.
The proposed fake pills amendment responds to concerns expressed by the Drug Enforcement Agency about the proliferation of fake pills, that is, illicitly manufactured pills that represented or marketed as legitimate pharmaceutical pills containing fentanyl or fentanyl analog. The proposed amendment would respond to these concerns by amending 2D 1.1B13 to add a new subparagraph with an alternative two-level enhancement for cases where the defendant represented or marketed as a legitimately manufactured drug another mixture or substance containing fentanyl or fentanyl analog, while having reason to believe that such mixture or substance was not the legitimately manufactured drug. The new provision would also refer to 21 USC Section 321G1 for purposes of defining the term drug. Issue for comment is also included. A motion to publish the fake pills amendment with a public comment period closing on March 14, 2023, and technical and conforming amendment authority to staff would be appropriate at this time.
Is there a motion to publish the proposed amendment as suggested by the General Counsel?
So moved.
Is there a second?
Second.
Is there any discussion on this motion? Well, let's take a vote. Those in favor of this motion, please say aye.
Aye.
Aye. Aye.
The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The General Counsel will now advise the Commission on a possible vote concerning a proposed miscellaneous amendment.
The miscellaneous amendment contains 2 parts, each of which is not mutually exclusive. Part A responds to a guideline application issue concerning the interaction of 2G 1.3 and 3D 1.2 and would amend 3D 1.2D to provide that offenses covered by 2G 1.3, like offenses covered by 2G 1.1, are not grouped under subsection D. Part B revises the guidelines to address the fact that the Bureau of Prisons no longer operates a shock incarceration program as described in 5F1.7 and would amend the commentary to reflect that. A motion to publish the proposed miscellaneous amendment with a public comment period closing on March 14th, 2023, and technical and conforming amendment authority to staff would be in order.
Is there a motion to publish the proposed amendment as suggested by the General Counsel?
So moved.
Is there a second?
Second.
Second.
Is there any discussion on the motion? Well, let's take a vote. For those in favor of this motion, please say so by saying aye.
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 The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. The General Counsel will now advise the Commission on a possible vote concerning a proposed technical amendment.
No. The technical amendment is also a multi-part amendment, but for your purposes, I will tell you that it simply makes technical changes in various places throughout the manual to provide updated references to certain sections in the United States Code, or reclassification of sentences in the United States Code, or to reorganize commentary to make it more readable and user-friendly, and or to correct typographical errors in the guidelines manual. A motion to publish the proposed technical amendment with a public comment period closing on March 14th, 2023, and technical and conforming amendment authority to staff is appropriate at this time.
Is there a motion to publish the proposed amendment as suggested by a General Counsel?
So moved.
So moved.
Is there a second?
Second.
Is there any discussion on this motion? Let's take a vote. For those who are in favor of proceeding with that proposal, please vote by saying aye.
Aye.
Aye. Aye.
Any opposed? Nays. The motion is adopted, and let the record reflect that at least 3 commissioners voted in favor of the motion to publish. Ladies and gentlemen, I'm talking to you out there in the audience and you out there on the website. As I said, the staff has really been working. The commission has been working. You heard all of these motions, and you know what's ahead of us that we're doing for you and for our system of justice. We got a lot of work to do, and we're still doing it. We appreciate all your support. At this time, I don't think there's any further business before the commission, except for, I'm pretty sure Jonathan Rebluski, representing the Attorney General, has some comments.
Thank you very much, Mr. Chairman. Thank you so much for your leadership of the commission over the last 5 or 6 months or so. As you point out, and I think as everyone in the public now knows, it has been a very busy few months since you became the chair. Together, we developed a very expansive agenda. We sought and received extensive public comment on that agenda from over 8,000 individuals and groups. And we are now publishing thoughtfully crafted guideline amendment proposals and again seeking public comment. You have guided the commission deftly, and we appreciate you bringing us to this day and to this stage in the process. At the Department of Justice, we care very deeply about the commission's work. From the Attorney General to line prosecutors in districts across the country, to our law enforcement colleagues and to our victim and witness advocates, the guidelines and federal sentencing policy represent an important element in our collective mission to improve public safety and to deliver justice to victims, defendants, and the general public. We think the guideline amendment proposals and issues for comment we are publishing today address very critical public safety and justice concerns, and also important guideline operational issues. From the opioid crisis to violent crime, from sexual assault of federal prisoners to the availability of probation for nonviolent first offenders, from the study of drug and other alternative courts to the dreaded categorical approach to determining what is and isn't a crime of violence, these issues all implicate fundamental fairness in sentencing. While we commend the Commission for what is being published, I think it's fair to say that some of the proposals go in a direction we find problematic, while others don't go quite as far as we might want. During the comment period, we will voice our agreement with some of the proposals and disagreement with others. Of course, this is how it should be, and we pledge to you our commitment to making the published proposals even better so that justice can be served and so that the American people can be safer in their communities. We think the deliberative process the Commission is following is a model, and we are looking forward to the more public engagement that will take place over the coming months, where we will hear in a public setting from lawyers, judges, individuals who have been directly subject to our sentencing process, victim advocates, law enforcement, and others. We encourage these stakeholders to speak loudly, and we look forward to their input. Before I close, I want to thank the Commission staff for its work. The issues we have faced together so far are complex and controversial. You are the true experts in the subject matter, and your search for sensible sentencing policy has been remarkable to see. On the amendment process, you have gone from 0 to 60 in no time, and you have made the publication of all of these amendments possible. It has been very, very impressive. Again, thank you, Mr. Chairman, for your leadership and for giving me this opportunity to say a few words. We look forward to the coming months and to the public hearings to come. Thank you.
Thank you, Mr. Wroblewski. www.ussc.gov. I encourage you all to keep up with the work that we're doing. Attend these hearings with us through the website if you can't be here, because this is important work that we're doing. And we have such a dedicated staff who's doing it. We have advocates on all sides who are participating. But there's no greater advocate than the public. So please, ladies and gentlemen, do participate with us by attending our hearings and offering your comments. Is there any further business before this commission? Hearing none, then, is there a motion to adjourn?
So moved.
Is there a second?
Second.
All right. We'll vote on that motion to adjourn by saying aye. Aye.
Aye.
It's unanimous.
Aye.
Everyone has voted in favor. The motion is adopted by voice vote, and this meeting is now adjourned. Thank you.